This event would have never been able to be possible without the help by Yoeli Fried, my personal friend from Friedco Media. Let's give them all a round of applause. Beautiful, beautiful event. Keep us on time. Which brings us to the conclusion of today's very, very successful gathering here, presented by PCON. We would like to introduce, last but certainly not least, a prestigious panel hosted by my personal friend and dedicated Oscan, Isaac Sofer, alongside highly distinguished panelists, and the topic will be reasonable perspective on how to adopt a new paradigm with rental laws. And Isaac will introduce the three panelists. Thank you for having me here, and good night.
Good evening. As Aaron did mention, that we assembled a beautiful, beautiful panel after hard work from the entire team. And the caption, the theme, is about the new paradigm after the June New York State rental laws has been passed. So there's a total new shift which is going to come upon us in the next 12 months. If PCON can do it maybe 2-3 times a year, it will be sooner, but we need now much more creative ideas from the panel, people like-minded. And let's start. We assembled a theme which includes an attorney, a senior attorney from Rosenberg and Estis. His name is Michael T. Carr. Michael joined the prominent law firm in 2018 after many years in practice in Brooklyn and L&T. He's a member of the firm's litigation department. Mr. Carr represents various types of clients in connection to real estate. His vast knowledge is tremendous. He used to be in Brooklyn representing real estate firms, investors, developers, and single-family homeowners. His focus is practice on handling disputes involving complex landlord-tenant matters, real estate ownership, and commercial litigation. Mr. Carr, welcome. Then we have a senior CPA with a lot of practice in the real estate management industry. His name is Ephraim Fasten. Ephraim is a senior partner in the Fasten Halberstam LLP based in the borough of Manhattan. He has been over 15 years of professional experience providing public and private companies with accounting, auditing, and tax services. His extensive knowledge in the real estate industry has led him to be a source of creativity, information, and especially in this changing era. Ephraim's hands-on experience enables him to relate in changing the business climates. Let's hear from Ephraim. Then we have a mortgage expert, a prominent sponsor of PCON tonight. His name is Stephen Hersko. He's CEO of SHB Group. Everybody saw him today. He's a vast knowledge in real estate financing and investment professional who has closed over 5 billion commercial real estate value transaction. Loan size have ranged from under $1 million to well over 100 million. His keen understanding of what it takes to close a deal makes him sought out by both loyal and new clients, recognizing that cookie-cutter mortgages bankers may not have the ability to resolve their needs in the more difficult of projects. Stephen. Last but not least, we have now a distinguished guest tonight, which is our privilege and honor, Honorable Judge Rami Smith. Judge Smith is a housing judge in Kings County Civil Court. She lives in this borough, in the great borough of Staten Island. The judge is a proud practicing Jew and was in court clerk for many years in civil court. The judge gave us the honor and opportunity to be with us tonight. We are grateful for that appearance, Judge. We assembled so many questions that mean the feeding of the feedback out of so many clients. And we're talking about over here management companies, sophisticated managements. It's not that those questions are real challenging, but we'll try, as the theme is after June 2019, we have new laws. So we'll try to focus, all the questions will be focused on that. We'll start with Attorney Carr. First question. Being that you are a professional in the field for a while and you follow many complicated situations, what would you advise now owners, managers to be on the lookout to avoid falling into the spiral of issues that will hurt their properties as opposed to till now? A question, which is a double question, is if owners are in the middle of something now, should they pursue even although it's not according to their business model or business plan as it was before June 2019?
So the first part of the question was the pitfalls? Okay.
Not to fall into pitfalls.
So under the new rent stabilization laws, what owners and what management companies need to be on the lookout the most is statutory compliance now. Before, where you may have been able to get away with being a little bit loose with your records, it's not going to pan out well anymore. And that basically means, let's take, for example, the overcharge claims now for a rent-stabilized tenant. The statute of limitations now is 6 years, and look-back period is whatever is reasonably necessary to ascertain what the legal regulated rent should be. Which means if you don't have records from 2 or 3 years ago showing what the rent collected was, what the leases that were in place were, and if you have a tenant that claims an overcharge, even though you may not be overcharging, because the burden of proof is on you as the owner or the manager, you're not going to be able to disprove the overcharge, and that may lead to some serious consequences. So bookkeeping and record keeping at this point in time are extremely, extremely important to make sure that you can prove that you're complying with the law. Because 9 times out of 10, one of these claims, when it comes along, the burden of proof is immediately going to be shifted onto the landlord. Second is being familiar with what the laws currently say. There's a lot of things that affect your day-to-day operations immediately. One of those being the notices under RPL 235, which basically means you have to send your tenant a reminder notice now that they didn't pay the rent if you haven't received it within 5 days. And another being the handling of security deposits. You have to make sure that if you're going to draw down the security deposit, that within 14 days, you give your tenant notice, a detailed notice as to what charges that you're taking out of the security deposit. If you don't do that, you have to give the entire security deposit back. So there's a lot of little nuanced changes to the law that are going to affect your day-to-day operations. And you have to ensure that your team and that your managers know what those are. Because if you get caught breaching one of the laws or breaking one of the laws, and the tenant makes a complaint, you're going to suffer damages. You're going to suffer consequences from it. So, again, knowledge and compliance is at an all-time high. As far as investing, if you have current investments into your properties and you're looking to either deregulate or raise the rent substantially pursuant to MCI increases or IAIs, there's not much incentive to keep those projects going right now because unless the laws are challenged and overturned, which may take years, as Michael from RSA spoke about, you're not going to be able to recoup that money, not under the new rent regulatory scheme. And that's unfortunate because you're halfway through a project that the money you've invested is most likely gone, capped at the $15,000 limit. So you have to be very judicious in how you're going to spend the $15,000 you're allotted over 15 years or $30,000 over 30 years as how you want to invest and spend your money. But if you have a current project right now, there's not much incentive to finish it out. Of course, you want to comply with law and make sure that you don't leave it half finished where you're going to get hit with a DOB violation or something of that manner. But that's what I have to say about that.
Thank you. The next question is for Ephraim. as a professional a CPA, done many times before, probably, management's probably called you upon what they can do to save $1. But now it's more important than ever. And upon the challenging times that's coming ahead of us, what would you suggest this first discussion should be between a management and an owner? Same goes, where do management look for savings? Where does owner management look when he knows time to act or it's trouble?
Okay, I think the first discussion that should be had between the management company and the manager should probably be what's expected. To take a look at projections. I find many of the small businesses and many of the small people that run businesses and get into this business, they don't actually work out the numbers from the beginning to end on what's expected. So when they go in and they make an expenditure, what is the actual return of the expenditure, and is it worth it or is it not? I also think that there's a lot of things that happen today that are, till today, that were reactive. For example, we're going to get into people getting fines and penalties, where if they would have just taken the time to go ahead before that and check the building and made sure that they could do the work before and they won't get these penalties, you'll have a big, there's a lot of money to be saved and a lot of money to be had that way. Now, yes, sometimes it gets complicated and sometimes, you know, they're kind of going to find some type of penalty or some type of fine, but many of these penalties and many of these items that happen in building management are reactive, and if you can start doing proactive, as well as building a projection before, there will be many cost savings possible. There's also many times people can take, when you buy a couple of buildings or you're managing a couple of buildings, and you can start thinking about pooling expenses. Many people run buildings to say, oh, this is one building, this is another building, and this is another project, and this is another project, but instead, maybe pool the project and think, okay, what can be the cost savings if we put the projects together?
What can you advise on expenditures like liability insurance or energy savings or
So as
all
people,
cost measures?
right, so as
Let's
people
give it
grow, there are a lot of new different things that can grow with you. You have to be careful with some of these things I'm going to mention. For example, captive insurance. When you start getting a little larger, it might be something to think about. Self-insurance might be something to be thinking about. Pooling with other management companies for insurance and buying it as a pool. Making sure you do it protectively and do it properly, buying stop-loss insurances, and not going into small plans. And again, it's not for here to go through the details, but things like that. Getting employees that are good. How do you attract good employees? By going out and getting benefits for them. Everyone thinks that's very expensive, but today there's something called PEOs, where you could go out and hire employees, offer top-of-the-line benefits for very, very little, probably less than what some of you are paying today for your health insurance in New York, especially in New York.
Next question is for our mortgage expert. Steve, it's one big question. I know you have a long day over there, being there and explaining a lot of people, probably people have heard already some knowledge of yours, but how should owners, now in this time, prepare for the mortgage maturity? As you know, a lot of banks going out of this type of model, the financing. A lot of people, they're tightening the belts, they're tightening the underwriting. Give us advice after June. How would a management, an owner, prepare himself for when the mortgage is due?
To Hillim.
That's a Jewish answer. Now,
It's a complicated question. I mean, if the asset is performing, so there shouldn't really be much to worry about it. Most of the lenders on the savings bank side have changed their guidelines post June 15th. To name a few, I'm sure most of the crowd here has dealt with Signature Bank. Signature Bank used to be a 120 debt covered lender and has changed it to 130. That's a tremendous differential in bottom line. Valuations have changed, cap rates are going up because of this, and there's a lot of speculation. I mean, there's still a we're in an era of unknown. We hope that the ongoing litigation will prove out, but right now lenders are taking a very, very hard look at their assets and not as aggressive. I had a call today actually with Chase. We had a term sheet a few weeks ago, a full-term interest-only deal. It was a 60% loan to value, and today that term sheet, if I would want to match it, I'd have to underwrite a 150 debt cover at a 50 LTV. I mean, the bottom line of that is a difference of hundreds of thousands of dollars of NOI, which is obviously a tremendous impact. So the bottom line is that the last 15 years of real estate has been mostly, in my opinion, been a function of trading, not really a function of good old-fashioned real estate, of monthly collections and making money. And that era for right now is over. How we deal with it, it's really unknown.
So basically you say it's unknown.
Like I said originally, Tehillim. I mean, it's not unknown. I mean, any deal that you have that is just towing the line that was speculative over the last couple of years. Let's go back in time. Realistically, and again, I don't know the crowd when they've started, but from 2010 and onward, most multifamily owners on rent-stabilized assets monetize their projects one simple way. It's called interest rates. It went from 6% to 5.5% to 5% to 4.5% to 4 to 3.5 to 3. And lucky for guys like me, every time it dropped, I made a phone call and said, hey, you could take out another $1 million. That was the way we made money, and that's the way most ownership has made money. I mean, I think most of the crowd will agree to it. From what I see, I would say 95% of this crowd is young. It's not older generational, and that's the way ownership has made money over the last 10 years. With higher debt coverages and higher cap rates, it's over. I mean, you want to know how we restructure what we do? Very complicated, different ways of doing it. Interest only, Wall Street CMBS transactions, mezzanine financing. Leads me to a whole different conversation is where is financing going over the next 10 years, where lenders are going to be for the next 10 years. I personally believe that alternative lending will be the new norm. Signature banks, the New York community banks, the JP Morgan Chases, all those lenders everybody's been used to using is no longer going to be the regular first place to stop for financing. You're going to be dealing with different hedge funds that are not as restrictive, that are looking for different avenues to make money, and that's probably going to be the financing landscape, in my opinion, over the next couple of years.
Thank you. Next question is for our honorable judge. Since you were in the civil court for a long time and recently became a housing judge, we would like to share with our audience some insight why judges are not attentive to landlords, especially when it comes to access, frivolous complaints, and tenants that everybody in the room knows that they are frivolous.
We take an oath of office, so we are meant to apply the law as it's written, obviously with fair interpretation, and now the law is new for us as well. You have to keep that in mind. It's new for us as well. But there's one thing that will get our attention, and it's being right. Know this law in and out. Make sure your lawyers are not afraid to know it, to be able to argue it, to understand the nuances based on what has happened up until now, how to make those arguments based on that and on what's written now. Keep in mind, we all now are figuring out how we're going to apply it. And some of it isn't as clear as the prior laws were. So you need to convince us clearly, simply, and be right. We can't ignore that. Attention, no attention. If you convince us, we can't do anything but dismiss a frivolous case if you show us it's frivolous, or you can simply poke holes in a plaintiff's case in showing us that. We don't want to be reversed. We don't want cases to go up to the term, to the division, and be wrong. We have egos like everybody else. So if you can simply let us know, this is the right answer and this is why. I worked for a lawyer years ago, and he said, judges don't want to read pages and pages and pages and opinions and politics. They want to know why they should rule in your favor. And I love it. I love when I see a good argument and I know that I can do something that will likely stick. So know the law and make sure your attorneys are not afraid to push and to go up to the term in the division, the appellate courts that tell us we're wrong. Make sure they're not afraid to do that, because now's your playing field.
Thank you, Judge. So helpful. I want to announce that if everybody has a question or a follow-up question, what has been said, please send up some notes. We will take it now. Follow-up question to the judge. Is it fair to say that if somebody has a clean record, no violations, no history with the tenant, or no HPD violations, no building department, is a small owner, has no trouble till now, suddenly, all of a sudden, the tenant don't pay, will the judge be more attentive to his needs, or it's what the system is all about?
Facts speak for themselves. So we as judges on one particular case, for example, I'm not really allowed to go what's called outside the record and research somebody, either the tenant or the landlord. I can look at certain things. HPD violations, for example, and right now I happen to be in the violation part. So I can look up and see if there are other violations in the building. That's fine. It's according to the multiple dwelling law and New York technology law, that's admissible. So if something's admissible in evidence, I'm going to be able to look at it during a conference or even during a trial. But whatever's offered to me as facts, and if it's in admissible form, I'm considering it. During a conference, has it happened where someone will say, I'll notice, this is the only violation in the building. What's going on? You inquire deeper. And again, with HPD, it's pretty simple. It's either a violation or it's not, and I'm sure all of you know that there's really, the defenses don't come into play until it starts getting a little bit more beyond the initial orders to correct, which somebody might have mentioned before, just do the repairs, do it. Then we're not even at that stage. And then you know when you're deep into a case that's not resolving, yeah, there's something going on. And I'll try to look into it. Within the bounds of admissible evidence, obviously.
I'm not letting you off so soon. Since you mentioned your HP part,
I shouldn't have said that.
just in general terms, we don't want to push the judge. We understand there is limit. But HPD is always pushing for a settlement and before the judge. And sometimes it's worthwhile to go to trial, sometimes not. When is it and when is it not?
Again, if you, I'm sorry, Friam, if you, and as you said, Mr. Carr, if you have your books and they're good, and you have your records to show that you went in and did repairs, the best thing a person can tell me is that, you know what, yeah, I fixed it the next day, I gave my certification. Whether or not HPD ever went back out, that's not what I look at. If they took the certification and there wasn't another violation written, that's something they can show me, and that would be convincing. Again, you just apply with the code, comply with the laws. But I always ask people, you're settling this case. Is this what you want to do? Whether it's a two-family owner, whether it's a huge building, I'll always ask, is this what you want to do? You don't want to try this, you want to pay this amount. So people can say, well, I don't know why I'm paying it. And then I take a step back. Well, then why did you sign this? So it's similar to a tenant. If a tenant doesn't think they owe $3,000, why are they going to sign that they owe it? So landlords should know, if you have something to justify not paying the fine, bring it to court. Bring it the first time. We'll look at it. I'll look at it. And you should demand that someone look at it.
Thank you, Judge. This question is for Mr. Carr. You mentioned, it's a follow-up question, basically. You mentioned that the new laws is asking for keeping records, of course, instead of 4 years, 6 years, correct?
No, actually, so the statute of limitation on an overcharge went from 4 years to 6 years. Your duty to maintain records is going to vary depending on what type of records that we're talking about. But for example, if you're going to do an individual apartment improvement, any increase you get from individual apartment improvement now will phase out after 30 years, which means right now, everyone in this room, if you're going to do an individual apartment improvement, has a duty to keep those records for 30 plus years, because when they phase out, which means the increase you took from the individual apartment improvement, as well as any RGB increases you've taken also on top of those, will also phase out. You're going to have to show the math of what the actual legal rent could be. So it's very possible your legal rent over 30 years may go from $1,500, let's just say $2,000 to make the numbers easy. Of that $500 increase, 200 of those dollars may phase out because they were based on individual apartment improvements. So depending on what type of records we're talking about, you have to keep them for much longer. On top of that, for receipts, for example, those records have to be kept for 3 years according to the statute. So there's different record-keeping requirements for different areas. But at the moment, the best we can tell you is keep your records for as long as possible, especially in the digital age now. You can scan them in, you can keep them digitally without having to take up a lot of space.
Thank you for that. Now, there is recent, since the new laws are so new, there's recent clarifications from various brokerage and law firms that although we can only ask $20 for application fee, we can ask for certain other fees what cause the management or the owner to process that new tenant. In your opinion, is that legal? The same goes to deposits. Deposit has been forbidden, limited to 1 month. There's a new trend of insurance towards deposits. In your opinion, is that legal? Is it gray?
Oh, so going to the $20 fee, that's statutory. You can't charge more than $20 to process a tenant's application now. And that includes the background check, any administrative costs you have, it's just capped at $20. There really is no way of getting around that. What I have had many clients ask me is regarding services such as insurance or Rhino, if those are now legal under the new rent regulations. And at least with Rhino, because I've studied them more particularly, they actually happen to be a client of mine, I can tell you that Rhino, under the statute, they sell a bond. They bond the lease. So for example, instead of taking, let's say, 1 month security, you can have your tenant, at the tenant's cost, buy from Rhino a bond. And that bond could be 1 month's rent, it could be 6 months' rent. And if the tenant breaches, then you would have the ability to draw down on the bond. Now, under the statute, if you read just black letter law, that seems to be statutorily compliant because you're not accepting a security deposit which would be greater than 1 month's rent, even if the bond is 6 months' rent. It does seem, though, to be very blatantly going around the statute. So how a judge is going to rule on this, if someone challenges in Supreme Court, which is most likely where a security deposit issue would be heard at either civil court or Supreme, not housing court, how a judge is going to rule on that is left to be seen. And that's kind of the problem with the new laws since June 14th, is that you and I can interpret them as much as we want, and we can come up with opinions, but our opinions, respectively, they don't count unless we can convince a judge to go along with the same opinion. So at this point in time, the bigger issue is managers and owners need to start getting creative on how they're going to keep their profits up and also how they're going to mitigate potential damages. So companies like Rhino, companies like Resi, companies like Insurant are all companies that are going to probably experience a boom very quickly and very immediately. Whether or not they're going to survive judicial challenge later on is yet to be seen. So it's impossible to say right now if any of these practices are legal because they haven't been subject to litigation, to scrutiny, and to judicial interpretation. So I would say everyone out here should be very creative, but also be careful as well, because the consequences for going around these statutes can be very grave.
Thank you so much. One follow-up question for Steve. Oh, I woke you up. What sort of mortgages do you expect bank to call that people need to, when it's up for refinance, even they will refinance, that you need to put in additional funds as opposed to getting an increase in finance? I think you touched that, but you said basically it's unknown, but I think you have some sort of ball figure. I'm going to ask people should put in. what sort of notes do you think? When do people know in the audience?
Again, I think probably over the next 9 months, 6 to 9 months, with the interest rates decreasing, any multifamily owner should be looking at his assets to refinance. I can't predict, again, what will happen with legislation, but right now, if you have the opportunity to stabilize an asset long-term, that would be my advice. And most of my clients are doing that. And a lot of our clients in the larger loans, we're taking long-term financing. It's actually not good for the mortgage brokerage business. 10 years fixed, interest only, long-term. I don't get to collect my fee every 3 or 5 years, but it's definitely worthwhile. The assets are stabilized and they have 10 years to worry about it. Because if short-term loans the next 2, 3 years potentially have tremendous risk and at the inability to be able to refinance.
Thank you so much. I have a gentleman who wants to ask a few intellectual questions, so to speak. His name is Isaac Katz. Welcome.
Thank you. I'd like to address the question to Judge Smith and Mr. Carr. What would you advise a landlord to do if they're being sued by HPD for noncompliance, for not removing violations, where the violation in question it's out of the hands of the landlord? For example, a gas shutoff. You have a situation today where it can take Con Ed 4 months or longer easily to get an appointment to come turn on the gas. So you get a C violation for insufficient gas supply. You have it resolved in a week, 2 weeks, whatever your plumber needs. Then HPD says you haven't rectified the violation within the specified time, and they want to apply per diem penalties. And they'll come to court, they'll say, look, we can give you $50,000 in penalties. You haven't fixed it. There's no gas. And it's out of the owner's hands. How would you advise them to deal with that?
And this occurs. So
Yes.
first, I can't advise anybody to do anything. So I can't. So there is law that deals with this. If there's a real reason that something's not getting repaired and it's in the city agency's hands or any kind of agency's hands, it's a third party, you can make that argument. I go to the DOB website, and there's not a permit application to be found. So if you come in, again, as I said before, and you have even better, you can get the plumber to court or on the phone. When it gets to trial level, obviously, you're not going to drag them everywhere you go. Or you have the applications filed, you have the permits, and you can show me this is in the works. Much different story than I think the plumber's coming, he was scheduled, but he didn't show up. I don't know what's going on, which I get too, from everybody. So again, as much backup as you can that tells me I would be wrong on the law if I looked at you and said, you have to pay these fines, no defense.
So if I can just follow the question up. One particular case that I'm familiar with, where not only was the permit filed, permit was filed, work was done. Pictures, HPD called the managing agent and said, a week before the scheduled trial, they said, can we see a copy of that permit, and can we see it was sent to them? They pressed ahead with the lawsuit anyhow. And their statement was essentially, look, you can settle with us for $7,000, or we can go to trial where we'll be asking for $50,000. How would a judge look at that case if it came to trial? Permits are filed, work is done.
Yeah, I can tell you how I would look at it. I don't know any other judges, but I like when I see everything before me. I would try it. If the people wanted the trial, I would try it. And then I would think about it, and I would consult whatever statute governs it, and I would make sure it's the right answer. Try your cases. If you have all your paperwork, try them. I mean, this is what we are for. We're not here so we can get out of work early. We're here to make sure we can address everyone's concern and ultimately set some precedent for other cases that are going to come next. And if a bunch of people just say, well, I want to leave, or I'm not in the mood for this, so we're never going to really have that good precedent, especially when no one wants to pay for the appeals. Because appeals, I can, if he's a judge, Judge Carr decides something in the same place I'm in, I could ignore him, I could do what he did. But the term in the division or Court of Appeals, whatever, higher court, I should do what they told me to do. Right. So, as I said before, make sure your lawyers are ready to go the whole distance, because we need, I'm speaking for myself now and my colleagues, we need good law on this law. We need good cases that really give us instruction, 100%.
Thank you, Your Honor. Is there anything you'd like to add?
Just to echo what Judge Smith said, again, the record keeping is paramount. There's nothing that frustrates me more when I have maybe a case with those exact fact patterns and the client can't provide the documents to back it up. And they say, well, I did the repair and I called the plumber. Or I sent the plumber and the tenant wouldn't let him in. Okay, do you have a record of when the plumber went? No. Which plumber did you use? I don't remember. And that doesn't help because then I don't have evidence to bring to the judge to prove that you're in the right. You also have to decide too, especially with a case like this, is in the HP part especially, generally it's the same attorneys that are there day in and day out that represent HPD. So sometimes it may not be cost effective to try a particular case that you may be correct on because the attorney's fees may cost $5,000 and you're looking at a $3,000 fine. That being said, sometimes you have to decide when you have a good case, when it's worth taking a loss on that particular case to show HPD that you're not going to get pushed around the next time they come, and to also show them that you have the records, and then you can start giving yourself a better reputation. Now, hopefully you're not in the HP part that often, because if you are, that means you probably don't have a great reputation. But there is a way to make a name for yourself. Those attorneys will remember me, they will remember you, they'll remember the case, especially if you force them to go to trial and you beat them. So sometimes you have to decide, even though it may not be cost effective on paper, it may bear fruit later on to go to trial on a case that you know you're going to win on. But again, everything is going to live and die by the records. I cannot create facts for you. I can only argue the facts, and I can argue the law, and I can try to spin them to help you and to benefit you the most. But I cannot create the facts. And if you don't have proof of the facts, the judge is generally not going to want to hear, I did this, without having any proof. It's just not going to work. So, especially after the new laws, record keeping is paramount. There's one thing I want you to take away from tonight is you need to make sure your records are immaculate, whether it's rent ledgers, whether it's your renewal leases, whether it's your repair records, everything needs to be documented. With phones and technology now, it's very easy to do. They have GPS on phones. If you're going to send your super out to a tenant's apartment and the tenant doesn't answer the door, you can have your super check it on their phone GPS and take a picture of the door or take a video of themselves knocking on the door. And this way, when I'm back in front of Judge Smith about a month later and she asks, how come the toilet isn't fixed? I can say, I sent the super 5 times. Here's 5 separate videos of him knocking on the door. Here's a video of the tenant opening the door and telling the super to go away because they don't want to give them access. Then you're going to be less likely to face any kind of consequences in court where we can show that you've been doing your due diligence. But if you just come in and say, they wouldn't let me in, and the tenant, of course, is going to say, I was home all day, no one ever knocked on my door, it comes down to he said, she said.
Thank you very much for your insight.
One more question from Mr. Carr. Application fee for third-party brokers, same as well as broker fee for management companies. What about fees became the application fee for third-party?
Right.
So the law, the new statute changed so many
Right.
things. Now people want to circumvent and see where.
So this is a statute I don't think you're going to be able to circumvent, whether it's the owner processing an application fee or management company processing an application fee. I believe you're capped at $20 because whether it's the owner or the owner's agent, the agent is only acting at the owner's direction. So if it's challenged, it's going to come down to they're going to hold it against the owner, in my opinion. Does the statute say that specifically? No, but this is not something I think I would want to try to get around, not at this point in time. I think you're stuck with the $20, unfortunately. There may be other ways of exploring, possibly trying to get a guarantee fee or a guarantor. There's other creative things that you can try, but again, nothing right now is necessarily legal because there hasn't been any interpretation unless you're going to strictly comply with the statute and take the most conservative approach possible. In case there's litigation, then you at least know you have a good argument to make that you didn't violate the statute.
I have another gentleman, a senior member of PCON all year round long, Brian Lefkowitz.
Okay, sorry, it's a little bit impromptu, but I think the easiest way to ask a question is to tell a story and get some direction. Generally, today, the way we do business is trying to be friends with our tenants and trying to be on one page and trying to go by the rule, keeping the buildings up to date, making sure we're violation-free. But that's true for 90% of the tenants. You have the 10% of tenants, which are always problems. So the story is, 2 weeks ago, we started a non-payment case. Tenant calls 311. That apartment has the exterminator going there twice a month. Tenant lives, I mean, you wouldn't want to walk into the apartment. We gave her a beautiful apartment. We paint the apartment every year because we're in court every year. HPD comes, issues about 15 violations. No smoke alarm, which basically, that law by itself, the tenant is supposed to maintain the smoke alarm. How could HPD require the landlord to make sure that the tenant does not remove the smoke alarm? If they really want to care the building should be safe, then by making us responsible that the smoke alarm battery isn't removed, that's not effective. Second of all, the tenant, now I have a bed bug violation. The tenant went and brought in outside furniture. Tenant told me, brought in the furniture, and we have new guests in the building, bed bugs. I'm not sure if you're familiar what the cost is, but this is a situation for itself. The tenant leaves the garbage in the apartment, so there's more guests in the building. Double guests. You have mice and bugs, because you could do the best work of extermination, but if the tenant does not live in clean conditions, this is what's going to happen. The next violation I got, that the window glass was broken. I could tell you that neither my super or anybody from the outside had access to knock out that glass. This same tenant, children threw stuff into the toilet, not once, about 6 times, flushed the toilet, water down to the tenant below. Now the tenant below is a very decent tenant, and she calls me, and I have to be mitigating the issue. I'm caught in between, because I don't want to get the tenant upstairs upset because she's going to call 311. So basically, you have these tenants. So in the last few months, when this issue happened with the water coming down on the tenant, I was hesitant to go to court because everybody's advice was, including my attorney, was you're going to court, you're going to waste your money. You're not going to get anywhere with this tenant by taking her to court. And at this point, where we're trying to operate very efficiently, we're watching every dollar we spend. So how do we go about a tenant like this in this environment to be effective? I'm not looking to get this tenant out, but I'm looking to keep the building safe, clean, and this tenant, not because of myself, but for the other tenants in the building, would be better off not living in the building. That's our question here, the story, and I'm looking for advice.
So have you discussed with your attorney a nuisance holdover, which is a pain, but has at least been broached?
We did discuss it, and the answer was not going to get you anywhere.
Well, so nuisance holdovers are extremely difficult. They're hard to prove, and judges are usually loath to evict stabilized tenants on nuisance or a substantial breach of lease obligations, which would be another flavor of holdover you could possibly bring. You're going to have the issue. It's going to be, under the new statutes, rebuttable presumption that's retaliatory because violations were issued against the unit, which is going to be a problem. But at the same time, if you have a lot of other actions that you can prove that the tenant took, you can try putting pressure on the tenant with a nuisance holdover. And sometimes that does not necessarily result in an eviction. You can do a probationary period where they'll agree to quote unquote behave for some time, and if they breach that, you'll have rights and remedies, which may include eviction. But you may want to get more aggressive with a tenant. Again, sometimes these are not...
Aggressive doesn't work anymore.
Well, you have two options, right? Really. You can be passive and do nothing, and you can keep dealing with the problem the way it is, or you can take matters into your own hands and try getting aggressive. There is no other option. I'm not saying it's going to necessarily get you the exact result you want, but it may improve the situation. And you can bring the holdover, you can fight the holdover, and you may settle with her. or you may not. You may have to try it. But then it brings me back to my discussion before. The more proof and the more facts you have of the things that she's doing, and not just, I know someone flushed it down the toilet because it could have only been her, which is a good argument, but still, it's not affirmative proof that she actually did it, right? So, again, the better the records you have, the more likely you'll be able to succeed on a holdover case. It's going to be very expensive, it's going to be time-consuming, and it's going to be a headache. But you have to decide, is it worth the X amount of dollars that you're going to put into it to possibly get peace in the building? And the other thing that I will add to that as well is that if the other tenants are actually having a problem, I've tried about 5 nuisance holdover cases over the past 4 years. And I would say the ones that went the best were the ones where other tenants in the building came in to testify against the problem tenant. Because now the judge has a different lens to look at the case. They're not just looking at it as, well, the landlord just wants this person out because the landlord's a bad guy, potentially, which a judge may think. But if you have 3, 4, 5 other rent-stabilized tenants, which the judge is going to have their interest in mind as well, especially when it comes to nuisance, the judge may be swayed by that and say, you know what, the landlord may not be this big bad guy because there's 3 or 4 other tenants in the building that are saying she's as bad or worse as the landlord says. And that would give you some leverage as well. And a lot of the times my clients call me about these types of cases. I'll say, no problem, we can bring a case. Will the other tenants in the building cooperate? And the answer is always no. I said, well, if the answer is no, and the other tenants in the building are not complaining as much as you are, and you're saying it's dangerous and it's a hazard and it's a nuisance to the tenants in the building, if the judge doesn't have that evidence before him or her, they're not going to be able to make that determination. So if you can, again, you just talked about before, being friendly with your tenants, working with your tenants. If you're doing that, and they'll go to bat for you in court, that may help you at the time where you have a bad tenant that you actually need to evict.
Thank you. That was very helpful.
With that, we conclude the night, we conclude the panel. We would like to thank Jaffe Saltiel, who joined us tonight and made the panel happen. Thank you so much. And you have so many clients looking out for you over there. And with that, we conclude the night. Thank you all for being so late and being so gracious and answering the questions. All the best. Good night.